A divorce in Illinois is a legal process by which a married couple formally ends their marriage and resolves various legal issues related to separation. Divorce laws and procedures in Illinois involve several key aspects. Number one, grounds for divorce. In Illinois, a no-fault ground is irreconcilable differences, which means that the marriage has broken down beyond repair. There is no need to prove wrongdoing by either party in a no-fault divorce. Number two, residency requirements. To file for divorce in Illinois, either you or your spouse must have been a resident of the state for at least 90 days prior to filing. You can file for divorce in the county where either you or your spouse currently resides. Number three, filing a petition for divorce. The divorce process typically begins when one spouse files a petition for dissolution of marriage with the circuit court in the appropriate county. The filing party is referred to as the petitioner, while the other spouse becomes the respondent. Number four, legal separation. Illinois law allows for legal separation, which is similar to divorce, but does not officially terminate the marriage. Couples who choose legal separation remain married, but live separately and may address issues like property division, child custody, and support in a legally binding manner. Number five, property division. Illinois follows an equitable distribution system for property division, which means that marital property is divided fairly, but not necessarily equally. Marital property generally includes assets and debts acquired during the marriage, while separate property remains with the individual who owned it before the marriage. A judge considers various factors when determining the equitable distribution of assets and debts. Number six, spousal support or maintenance. Spousal support, also known as alimony, may be awarded in Illinois based on factors such as the duration of the marriage, the financial needs of the parties, and the ability to pay. Spousal support can be temporary or long-term depending on the circumstances. Child custody and support. In cases involving minor children, Illinois prioritizes the best interests of the child when determining custody or allocation of parental responsibilities and child support. Parents may create a parenting plan outlining decision-making responsibilities and parenting time, or the court may decide these matters if the parents cannot agree. Number eight, waiting period. Illinois has a statutory waiting period of 6 months from the date the divorce petition is served on the respondent before the divorce can be finalized. However, the waiting period can be waived under certain circumstances. Number nine, final judgment. Once all issues are resolved, either through negotiation, mediation, or court proceedings, the judge will issue a final judgment of divorce. This judgment formally dissolves the marriage and outlines the terms and conditions of the divorce, including property division, spousal support, child custody, and support arrangements. It's important to note that divorce proceedings can vary in complexity depending on the specific circumstances of the couple. Many divorces are resolved through negotiation and settlement, while others may require litigation. Legal representation is often advisable to navigate the complexities of divorce in Illinois, especially when significant assets or child-related issues are involved. If you need legal assistance, call our office now.